Well, welcome back again to all our listeners of Radio Entrepreneurs, and we continue to stream stories about entrepreneurship and business and this economy and how people are, we hope, succeeding. We don't want to bring a lot of failure stories. We haven't heard many. But our next guest, Tom McNulty, attorney, Lando and Anastasi, and we're going to talk about IP. This seems to be a big topic of the day, topic du jour. Welcome.
Hi, it's good to be back.
Thank you very much, Tom. So you're going to bring us a particular case, but before you do that, just tell our listeners a little bit about yourself.
Okay, well, I'm an intellectual property attorney. I primarily do litigation, relating to patents, trademarks, copyrights, trade secrets, things like that. I've been doing it for, 18 years now.
Wow. Oh, you're a rookie.
I feel more like a rookie than that. That's a startling number for me to sort of compute in my head.
Right, I understand. But you said you were going to unlock a pretty big case for us today.
Well, there was a case that came out a little bit earlier this year that had sort of an interesting result. It involves patent licenses, and when you license a patent, when you get the right to sue and when you don't get the right to sue,
right?
To prevent others from infringing. So the particular case involves a company called Unilock 2017.
Yeah.
Unilock is sort of a series of non-practicing entities, is the polite phrasing, patent trolls. They buy patents basically for the purpose of suing, collecting damages, licensing people under threat of lawsuit, that sort of thing. And they had bought a couple of patents from IBM several years ago, sued a number of entities in a number of different courts around the country, including a few in Massachusetts. This particular one involved a company called Paychex. Excuse me. And the lawsuit was brought about a year ago, sometime in 2019. The particular license that they got from IBM was sort of interesting. IBM was willing to, license these patents to them, effectively, quote unquote, sell these patents to them. But they didn't want Unilock bothering their major customers. So they included a clause that, excuse me, they retained the right to sublicense strategic partners. And there were some strategic partners that were identified by name. And then there was a sort of catch-all clause that anybody who had purchased at least $10 million in products and services from IBM over the last 5 years would qualify as a strategic partner. This leaves Unilock in sort of an interesting position of, until you actually file the lawsuit and conduct some discovery, you're not really sure who's going to meet that criteria and who isn't. So in this case, after going through some preliminary discovery, Paychex was able to demonstrate conclusively that they had bought more than $10 million in products, either directly from IBM or from other strategic partners of IBM. There was a bit of a dispute over whether that counted if it wasn't directly from IBM. The court ultimately decided it did. And given that left Paychex in the position of being able to obtain a license, Unilock was effectively denied standing in the case a year into the case, and the case was dismissed with prejudice. So it's sort of an interesting little thing that the way the contract is set up, they don't know who they can and can't sue until they're, at least waist deep in the water. But it's sort of brought to light. There's this idea of standing to bring a patent suit, and how important it is to when you're licensing in technology, and particularly when you're looking to get exclusive rights, to make sure that you will have the ability to bring lawsuits to defend those rights.
Right.
So in this case, one of the key factors is you can't sue anybody that could obtain a license that could legitimately obtain a license to the same patents, the same technology. And in this particular case, one thing I found interesting, Paychex didn't allege that they had obtained a license, just that they could, theoretically, if IBM were willing to grant them a license. But that was enough to have the case dismissed.
So is this significant for other companies who are filing for IP?
I think it's significant for other companies. There's a few things that you have to have in a patent license to give you the right to sue. You have to have some degree of exclusivity. And in patent law, that can come in a variety of ways. It can be patent law grants the patentee the exclusive rights to make, use, sell, import, things like that. As long as you have exclusivity in at least one of those areas, you'll be deemed an exclusive licensee that does have the right to sue. If you have all of the exclusive rights, you'll effectively be deemed an assignee. You'll effectively be deemed the new patent owner, and you'll have the unfettered right to sue anybody you want. If you're an exclusive licensee, but you don't have all of the exclusive rights, you can still file a lawsuit as long as the infringement is within the area of your exclusivity, exclusivity. But you do have to join the patent owner in the lawsuit because it's still their patent. They should have the right to take, or the right and the obligation, frankly, to take part in defending the validity of the patent, things like that. The one area that aspect becomes interesting, if you're an exclusive licensee but not an assignee and you need to join the patent owner, you might find yourself in a circumstance, depending on who the patent owner is, where they can't be joined and you can't bring suit. The example that really comes to mind for me is state universities that license out patented technology can claim sovereign immunity and refuse to be brought into a lawsuit. And if they're a necessary party to the lawsuit, then you can't bring your case forward, even though you do have some exclusive rights.
Does that sound fair to you? Just
the whole sovereign immunity thing is a little bit questionable, in my opinion. Once a university gets in the patent game, they should be subject to all the patent rules. But at least as things currently stand, that's not the case.
Well, it doesn't seem to be fair since a lot of patents are coming out of schools nowadays.
Yeah,
like they're not playing on the same field.
Yeah, exactly. And in particular, licenses coming out of universities tend to be sort of among the more convoluted ones that you really have to delve into and see what's there, because they've got goals and institutional aims that don't necessarily just involve making money. A lot of university licenses have requirements like benchmarks to meet to make the products available to the public, things like that. That also can, at a minimum, can require you to join them because they'll retain enough control in the activities in the patent itself that the courts will force them to join. I do know, not in the university context, but there was sort of an interesting case that worked against the sovereign immunity bit. Allergan, pharmaceutical company, they had some patents and some technology that they wanted to enforce, but they didn't want to subject themselves to certain proceedings before the patent office that you can undergo challenging the validity. So they assigned the patents to an Indian tribe. They retained the right to enforce the patents, but they assigned them to the Indian tribe. And then when people tried to bring proceedings before the PTO, they had the Indian tribe claim sovereign immunity. And that one didn't fly. They were allowed to be challenged at the PTO. So I'm not 100% sure what the distinction between the two sovereign immunity claims really turned on, but it was some creative lawyering. It didn't work out, but it was some creative lawyering on their part.
All very interesting, and IP is not necessarily in my skill set, but clearly in yours. We've been speaking with Tom McNulty, attorney at Lando and Anastasi. Tom, for someone who does need someone of that skill set, how would they find you?
Well, they can find our firm is at www.lalaw.com. And they can reach me at 617-395-7040.
Right. Thank you for being on the show again, and look forward to speaking to you next time on IP and the law. My name is Jeffrey Davis of Radio Entrepreneurs and also Mage LLC. You see my logos right there. And we're going to take a break. We'll be right back with more stories on Radio Entrepreneurs.